What I want to look at here is the uh, what I believe the influence of campaign contribution on the judge's decision, because Blue Cross and Blue Shield has never produced any documents, any witnesses, any evidence to substantiate their claims on statute of limitation and unlimited immunity. Our jury trial has been canceled 3 times in 12 months. The summary judgment that was denied by the visiting judge was overturned by the sitting judge. Um, and I believe that no evidence before a judge and make heavy campaign contributions is highly suspect of bribery. And I believe if I had made these, Blue Cross and Blue Shield would have made a huge cry of bribing the judge, of making a $5,000 contribution, a $3,000 contribution, and a $1,250 contribution. We'll look at that just a little bit later. Here are the decisions made by the judges, and you will see Judge Joe Kendall, who granted us a temporary restraining order, Judge Charlene Seaford, who dismissed 133 of 133 cases incorrectly. Judge Walter Orr heard the remanded cases from the DAB. Judge Barefoot Sanders denied Blue Cross and Blue Shield a summary judgment, motion for summary judgment, because they could not produce any evidence, and they have not. Judge David Kelton just delayed the case. He was running for the seat again and lost to Judge Cortez. The Honorable Kent Sims denied a motion for summary judgment, or no evidence motion for summary judgment, on March 9th. And then Judge Cortez rescheduled the trial from March 12th to August 20th, 2007. Here you will see John Scott, attorney for Blue Cross and Blue Shield, makes a $5,000 contribution on February 26th, the same day of the motion for summary judgment that they had filed. One was dealing with no evidence, and the other one was dealing with the statute of limitation and immunity preemptive issues. John Scott also made a contribution in 2006, August 8th, 10 days before the motion for summary judgment on August 18th. That was postponed, and September 18th of 2006, we were supposed to go to jury trial. That was canceled on that day. We thought we were going to pick jurors, and that was canceled. And then they make another contribution. Andrew Young of Scott and Young makes a $1,250 contribution. Make a $1,250 contribution on September 23rd, 5 days after the trial had been canceled. And November 7th, the election for Judge Kelton, and he lost. So we see that the counsel for Blue Cross and Blue Shield, who had no evidence, go in and bribe the judge, pay the judge off so that he would delay the trial. In this slide, you will see on August 8, 2006, a $3,000 contribution was made by Scott Young, John Scott of Scott and Young LLP, the representative legal counsel for Blue Cross and Blue Shield, $3,000. And on 9/23/2006, you will see the partner of John Scott, Andrew Young, make a $1,250 contribution, sandwiched between the September 18th trial date and the August 18th motion for summary judgment. Both were delayed and canceled. This was a remanded case from federal district court filed by Blue Cross and Blue Shield. We see jury trial, 44th District Court, September 18, 2006. Judge not familiar with the case. Very similar to what we talked about, the contribution before the summary judgment. After the trial was canceled, contributions of $3,000 and $1,250 made. by Blue Cross and Blue Shield legal counsel before the judge, in which we are going to have our court and jury trial. Let's look at this $5,000 contribution on uh, February 26, 2007 by Attorney John Scott of Scott Young LLP, $5,000 on the same day of the summary judgment. Here you will see the jury trial has been set from March 12, 2007 to August 20th, 2007. Perhaps the contribution had not been recognized by Judge Cortez because on March 7th he had a pretrial order that said that this trial is set for jury on 8/20/2007 at 9 o'clock. This date was chosen because it seems realistic based upon the information on file. You should consider this to be a final setting and be prepared to go to trial. If you do not think this is a realistic date, please notify the court administrator in writing within 10 days of the date of this order, indicating the results of your conference with opposing counsel. Discovery is to be commenced, accomplished, and completed pursuant of Texas Rule Civil Procedure 190 ETSE. We see the August 20th jury trial discharged because Judge Cortez grants the motion for summary judgment to Blue Cross and Blue Shield on June 27th, 2007, with no evidence.